Assalamualaikum and hello. We are from Group 4 and today we'll be discussing the case of Ketapang Trading Co. vs. Jembal Sendirian Berhad. This is our group members. Me, Mas MEGAH, ATIQAH DANIA, NURIN FITRI, SHADDAD SHAH and MUKHRIZ AIMAN. Together, we will be discussing about this case that covers several important legal issues related to contract law, including misrepresentation, breach of contract, force majeure, and the validity and enforceability of a commercial agreement. Let's begin by looking at the background of the case.
Okay, so for the introduction, this case is between Ketapang Trading Co. and Jembal Sendirian Berhad, and it involves several important issues under Malaysian contract law. Ketapang is a large electronic distributor in Asia, while Jembang is a manufacturer of high-tech electronic parts. Both companies signed a RM150 million supply agreement to support an electric vehicle project in Malaysia. However, the contract was filled in with problems. These include, first, dispute over who had the authority to sign, aligned mispresentation of product details, claims of economic duress, and a failure to deliver goods due to force majeure. Because of this, Ketapang suffer major financial loss and reputation damage, and they file a lawsuit in the Kuala Lumpur High Court. We will discuss about 7 issues in this presentation. So the first one is contract formation and apparent authority. Then second one is offer and counter offer acceptance. And then the third one is economic duress. The fourth is mispresentation, fraudulent. The fifth is invalid exclusion clause. And the sixth is breach of contract, delivery failure. And the last one is remedies for breach and mispresentation. So let's see whether this contract is valid or not.
Assalamualaikum, my name is DANIA binti AHMAD TARMIZI. My metric number is S70122. For the first issue for the Ketapang Trading Co. vs. Jembal Sendirian Berhad case is contract between Ketapang and Jembal be valid and enforced even though Ketapang director signed it without actual permission for amounts over RM30 million. For the law, we use of Section 10 of Contract Act 1950, a contract is valid if all parties agree freely, are competent, and the contract is for a legal purpose and involves a legal payment. For the case law, we refer from Freeman and Lockyer versus Buckhurst Park Properties, 1964, which summary of if a company makes it seem like someone has the power to sign a contract and another party reasonably believe they do, the company is bound by the contract even if that person didn't have actual permission. For the application, even though Ketapang director didn't have actual permission to sign such a large contract, the contract is likely still valid. This is because Jembal had no way of knowing about Ketapang internal rules. Based on the director position, Jembal reasonably believed the director did have the authority to sign. This is called apparent authority. For the conclusion, yes, the contract between Ketapang and Jembal is valid and can be enforced. Despite the director's lack of actual authority, all the necessary elements for a valid contract under the Contract Act are present. More importantly, because Ketapang allowed its director to appear as if he had the authority to sign the contract, Jembal was justified in believing he did. Therefore, Ketapang is legally bound by the agreement. For the second issue that we found, did Jembal initially reply to Ketapang request for proposal RPF create a binding contract, or was it a counter offer, and did a contract eventually get formed? For the law, we use Section 2 of Contract Act 1950, offer and acceptance, which state a proposal offer is made when someone shows they are willing to do or not do something hoping the other person agrees. For the case law, we refer from Height versus Range 1840. If someone makes an offer and the other person suggests different terms, that's a counter offer. A counter offer rejects the original offer, meaning the original offer can no longer be accepted. For the application, Jembal first responded to Ketapang RPF, which included new conditions like a higher price and different delivery was not an acceptance. Instead, it was a counter-offer because it changed the original terms. According to the law, this is cancelled Ketapang original offer. However, the situation changed later when both Ketapang and Jembal formally signed a contract. This act show they both agree to the final terms. This acceptance through conduct their action of signing mean a valid contract was eventually formed. For the conclusion, no, Jembal first response was not a valid acceptance, it was a counter offer which ended Ketapang original offer. At that point, there was no contract. But a valid and enforceable contract was formed later when both Ketapang and Jembal signed a formal agreement. This signing demonstrated that both parties had clearly agreed to the final terms, creating a binding contract.
So issue 3. Whether the threatening email received by Ketapang CEO amount to economic duress, thereby rendering the contract voidable at Ketapang option. So for the law is under section 14 of the Contract Act 1950, consent is not valid if it was obtained through coercion, undue influence, fraud, mispresentation or mistake. In the case of Universe Township vs ITWF 1983, the court ruled that a contract entered under illegitimate pressure can be voidable due to economic duress. So for the application, in this case, Ketapang CEO received a threatening email just 2 days before signing the contract. If it can be proven that the threat came from Jembal Sdn Bhd, this could be considered as economic duress. Similar to Universe Township, if the threat influenced by the CEO decision, the contract may not have been signed freely. However, one weakness in Ketapang case is that the CEO did not report the trade immediately and still went ahead with signing the contract. This delay might be viewed as accepting the term, which weakens their position. So for the conclusion is yes, the threats could amount to economic duress, but Ketapang must prove the threat come from Jembal. They did not accept the contract afterward. Otherwise, the contract may remain valid.
For issue 4, the key question is whether Jambal's false representation about the operating temperature of its component amount to the fraudulent misrepresentation, thereby allowing Ketapang to resign the contract and claim damage. According to the Section 80A of the Contract Act 1950, misrepresentation includes making a positive assertion that is not true, even if the person believes it to be true. However, in the case of the Dairy vs. Pig 1889, the court established that for a statement to amount to the fraudulent misrepresentation, it must be knowingly without belief in its truth or recklessly without caring whether it is true or false. In this case, Jembal claimed that their component could operate between negative 40 degree and plus 155 degree. But internal report contradicted this claim, proving it was false. This shows that Jembal either knew the claim was untrue or acted recklessly. Since Ketapang relied on this representation when entering into the contract, their concern was not genuine. Under Section 19 of the Contract Act, a party misled by fraudulent misrepresentation may resign the contract and claim damage. Therefore, Ketapang is entitled to cancel the agreement and seek compensation for any loss resulting from Jembal's dishonest conduct. Now we will go to the next issue, which is the issue here is whether the exclusion clause in the contract which attempts to waive protection provide Goods Act 1957 and the Consumer Protection Act 1990 is void for being contrary to public policy. Under Section 24 of the Contract Act 1950, any agreement with an unlawful object or consideration is deemed void. This includes attempt to override statutory right, means to protect consumer, the law in question named the Consumer Protection Act and the Sale of Goods Act provide essential safeguards such as guaranteeing product quality and fitness for the purpose that cannot be removed by private agreement. In the case of Sinadurai versus Kandasamy 1980, the court emphasized that contractual terms which seek to exclude statutory protection are generally unenforceable when they conflict with published policy or the purpose of the law. Applying this to the present case, Jembal attempts to exclude consumer protection is not legally valid. The clause goes against the intent of the legislation and public interest. Therefore, the exclusion clause is void and unenforceable, and Ketapang continues to enjoy full protection under consumer law.
Now, moving on to issue 6, whether Jembal's failure to deliver the goods due to a fire constitutes a breach of contract, and whether Jembal can rely on the force majeure clause as a valid defense. Under Section 40 of the Contract Acts 1950, if a party refuses or is unable to perform their promise, the other party has the right to cancel the contract. So, in this case, Ketapang can cancel the agreement if Jembal fails to deliver unless there's a valid excuse. Jembal might try to use force majeure clause as a defense, claiming that the fire was beyond their control. But for that to work, they must show that the fire was truly unexpected and not due to their own action or negligence. In this case of Pacific Hardware vs. Ong Yuk Lin in 1955, the court said that force majeure cannot be used as an excuse if the event was predictable or if the party failed to take proper precautions. That means if the fire was caused by things like poor wiring, lack of fire safety equipment, or weak risk management, then Jembal cannot use force majeure to avoid responsibility. So, applying that to Jembal's situation, if they failed to take reasonable safety steps and the fire could have been prevented, then it will still count as a breach of contract under Section 40. But if they can prove that they followed all safety rules and the fire was completely outside their control, then they may not be liable. In conclusion, Jemba's failure to deliver the goods does amount to a breach of contract unless they can properly rely on the force majeure clause. If not, Ketapang has the right to terminate the contract and claim losses.
We will now address issue 7. The issue in this case is what remedies Ketapang can claim due to Jembal's breach of contract and fraudulent misrepresentation. Specifically, Ketapang is seeking compensation for liquidated damages, the loss of a distribution contract, and possibly reputational harm. Law for this case is, according to Section 74 of the Contracts Act 1950, a party who suffers from a breach of contract has the right to claim compensation for losses that happen naturally or were expected by both parties when they entered into the contract. Meanwhile, Section 19 of the same Act allows a contract to be cancelled if one party gave consent based on fraud or misrepresentation. Two key cases support these sections. First is in Hadley v. Basandel, 1894. The two key support this section is first, in Hadley v. Basandel, 1854, the court established that damages can be claimed if they either arise naturally from the breach or were within the reasonable contemplation of both parties. Second, in Derry v. Peak, 1889, the court defined fraudulent misrepresentation as a false statement made knowingly or without belief in its truth or realistically. For this application, applying the law to the facts, Ketapang can claim 7.9 million in liquidated damages and 25 million for the loss of a distribution contract. These losses were likely foreseen by both parties due to the nature and importance of the project. Furthermore, since Jembal made false statements about its product specifications, which were later proven wrong by internal reports, Ketapang can rely on Section 19 on the Derry v. Peak case to argue that there were fraudulent misrepresentation. This gives Ketapang the right to rescind the contract and claim damages. If Ketapang can also prove that its business reputation suffered due to Jembal's actions, then a claim for reputational damage may also circuit. So, for the conclusion in this case is, in conclusion, Ketapang has strong legal grounds to claim several remedies. Under Section 74, they can claim compensation for financial losses. Under Section 19, they can cancel the contract due to fraud. The principles from Hadley v. Besendel and Derry v. Pick clearly support their position. Therefore, Ketapang is entitled to seek recovery for all direct and consensual losses, including loss of business opportunities and potential reputational damage.
To conclude, the overall conclusion is the contract between Ketapang and Jembal cannot be considered fully valid or enforceable. Even though it may have appeared valid at first, there are several serious legal issues, including fraudulent misrepresentations, an attempt to exclude statutory rights, breach of delivery, and elements of duress. Because of these issues, Ketapang has strong legal grounds to rescind the contract and pursue substantial damage. So, overall, the contract is not fully valid or enforceable under the law. That brings us to the end of our presentation. Thank you for listening and watching. That's all from us. Thank you.